The Supreme Court has reserved judgment in the suit filed by the 36 state governors seeking to compel the federal government to take up funding of capital projects for state high courts, sharia courts of appeal, and customary courts of appeal. The 36 states also want the federal government to pay the 66 billion naira expended so far on capital projects for the three courts. Celestine Area reports.
By virtue of Item 21E of the third schedule of the Constitution, the federal government is constitutionally obligated with the responsibility of funding all capital and recurrent expenditure of the High Courts, Sharia Courts of Appeal, and Customary Court of Appeal of the states in the country. It is in line with this that this relief is being sought by the plaintiffs in the suit. Counsel to the plaintiff Austin Alede, while arguing the case, informed the 7-member panel led by Justice Mohammed Datijo that the three courts are courts of the Federation, and as such, their capital projects should flow from the consolidated revenue funds of the Federation. The Attorney General of the Federation, represented by Titani Gazeli, opposed the request of the state and urged the Supreme Court to dismiss their request. The AGF predicated his argument on the fact that while the issue of salary and emoluments are expressly stated in the Constitution as a responsibility of the federal government, the section was silent on capital projects. He urged the justices to dismiss the suit and award substantial costs against the states. The Supreme Court extended an invitation to 5 senior advocates of Nigeria as amicus curiae to come give their own interpretation of the matter due to their constitutional experience.
Serious constitutional matter that affects the judiciary in Nigeria. The judiciary has always been under the jackboot of the governor and the president, commander-in-chief. But this decision will show that the people who framed our Constitution of 1999 had good intentions for both the states and the federal.
I adopted certain interpretation of law which did not allow me to align with them from the authorities cited, and the position of the law is as interpreted by and submitted to the court. I couldn't find myself admitting their own way of interpretation.
The Federation is just to bear allowances and salaries, not capital expenditure. So, but as you know, it has been argued. We are waiting for the wisdom of our noble laws.
You need to make a definite and definitive pronouncement on this issue so that the federal government will be alive to its responsibility in terms of funding of both capital and recurrent expenditures of the courts created by virtue of Section 6 of the 1999 Constitution.
We are of the view that federal courts are different from state courts. It is the state's responsibility to take care of state high court, customary court of appeal, and sharia court of appeal.
The Supreme Court reserved judgment that date will be communicated to parties when the judgment is ready. Celestina Area, TVC News, Abuja.